Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we are going to discuss the SEBI issue again. In fact, we're going to talk about an unusual story. It's called the Pinochet precedent. And it has lessons for SEBI and this whole turmoil over conflict of interest and propriety of its chairperson. Now, on the face of it, you would think a Chilean dictator accused of crimes against humanity, including torture, mass murder, and holding people hostage, is worlds apart from what Hindenburg Research has alleged about Madhabi Puri Buch, who is the chairperson of the Securities and Exchange Board of India. Yet, the principles of judicial propriety that arose out of a case that Augusto Pinochet filed in 1998 against his extradition resonates strongly with the current crisis in SEBI. This, of course, follows Hindenburg Research's accusations of conflict of interest and propriety, which we have discussed at length in my previous video blog. And if you haven't seen it, do take a look. So what is this Pinochet precedent? Quite simple, and you need to know the story behind it. In 1998, General Pinochet was in the United Kingdom for medical treatment. At that time, he was arrested in UK following an order by a Spanish magistrate indicting him for human rights violations. The case dragged on fast, unlike in India, and finally reached the House of Lords, which was like the ultimate appellate authority. Initially, the House of Lords ruled against Pinochet. This was in November 98. A month later, this ruling was overturned when it emerged that Lord Hoffman, one of the judges, had undisclosed ties to Amnesty International, which was representing victims of human rights violations in that particular case. It had been allowed to come in as an intervener. Now, it transpired that Lord Hoffman's wife was connected with Amnesty International, which is an NGO focused on human rights. Not that she was making money, it was more like social work. Same with Lord Hoffman. He too was a director and chairman of Amnesty International Charity Limited, which used to produce all kinds of reports, and one of them was a report on Chile's human rights violations. Now, General Pinochet and his legal team were unaware of this connection when that order was passed, but when they got to know of it, they filed an appeal. And they asked that the order passed by the House of Lords be set aside, or at least Lord Hoffman's decision should be considered non-est. Now, this was a 3-2 verdict, so that would have been important. So the case was heard again by a bench of the House of Lords. And the verdict was overturned. They decided that Lord Hoffman's failure to disclose his connection with Amnesty International, where he was a director, led to this 4-member bench of the House of Lords to conclude that his involvement in the judgment was an impermissible conflict of interest. Interestingly, all 4 lords on the bench held that Lord Hoffman was disqualified from participating in that case because of the appearance of conflict of interest, and they ordered that the case would be reheard. Here's what some of them said. So one of them, of course, the main speaker said that a person cannot be a judge in his own case, which is a well-established precedent. One member said, there has been no suggestion that Lord Hoffman was actually biased. He had no financial or pecuniary interest in the outcome, but his relationship with Amnesty International was such that he was, in effect, acting as a judge in his own cause. I consider that his failure to disclose these connections leads inevitably to the conclusion that the decision to which he was party must be set aside. Another judge said, in any case where the impartiality of a judge is in question, the appearance of the matter is just as important as the reality. As an aside, in 1999, the House of Lords again held that General Pinochet did not enjoy immunity, right? But all of them emphasized that the mere appearance of bias without actual bias was enough to disqualify a judge. And mind you, General Pinochet's legal team also did not accuse the judge of bias at all. This has led to a landmark judgment that underscores the ethical principle that a man may not be a judge in his own cause And this does not have to depend on a personal relationship or a financial relationship. Even the appearance of bias or a connection is equally relevant. This, if you ask me, applies 100% to the Securities and Exchange Board of India. Why is it relevant? Because look at the parallels between the Pinochet case and the current controversy. Hindenburg Research made 3 allegations against Madhabi Puri Buch and her husband. One, that they had investments in an offshore entity which was nested in a company which was under investigation by SEBI with regard to Adani share prices and specifically in connection with Vinod Adani. One. Second, Ms. Puri Buch had a 99% ownership in an advisory firm used by her husband for business consulting. This was 7 years after she had joined SEBI. Third, that she was promoting an asset class in which her husband had a perceived interest. Despite these allegations, or despite the connection, Madhabi Puri Buch had not recused herself from the ongoing Adani investigation as far as any of us know. This has raised serious concerns about the integrity of the regulatory process. Mirrors the Pinochet case. We don't care whether there was a real bias. There does not have to be a financial interest. The mere appearance of conflict is enough to warrant the recusal of a judge and someone who sits in the position of a judge. A capital market regulator which frames rules, sets standards, investigates wrongdoing by millions of investors. There are 9 crore investors today, and regulates thousands of entities starting from depositories, depository participants, stock exchanges, and what have you, is in a position of a high judge. Its job is to safeguard a market capitalization, which is the equivalent of $5 trillion US. This position is no different from a judge, and the standard set by the Pinochet case ought to apply here. This is not just my perception. This is a perception, without even referring to the Pinochet judgment, of a lot of people. The market regulator's response, first of all, is highly questionable. Its response was an unsigned press release defending itself and the chairperson without providing any details. Since then, at least 2 former bureaucrats have confirmed the impropriety of SEBI's actions as well as the chairperson's actions. In an interview with Karan Thapar of The Wire, former SEBI chairman C.B. Bhave said that Madhabi Puri Buch should have made her disclosures and recusals to the government, which is the finance ministry, to which SEBI reports, and the finance ministry ought to have responded as it thought fit. Former Finance Secretary Subhash Garg, who at one time, when he was the finance secretary, was on the SEBI board, told PTI that Madhabi Puri Buch's conduct was a very serious breach and it made her position untenable at the regulator. News agency Reuters has pointed out to a 2008 policy which bars SEBI officials from receiving fees from other professional activities. She owned a consultancy company, continues to own 99% of it. But these rules appear to have remained vague, even though SEBI has been inducting people from the private sector into top regulatory positions. Now, legal experts also concurred with the applicability of the Pinochet principle. In fact, M.R. Venkatesh, who's an advocate, author, and a chartered accountant, first sent me the link to the Pinochet order of the House of Lords and said this judgment is to the point and settles the issue. Senior advocate Sanjay Ghosh, who practices at the Supreme Court and the Delhi High Court, when asked, told me that applying this liberalized conflict doctrine laid down by the Pinochet case, it can definitely be said that when the SEBI chairperson directly or indirectly has some kind of linkage with an offshore entity, there was a need to disclose that to SEBI and even to the Honorable Supreme Court. More importantly, after the disclosure, the right and proper thing would have been to recuse from the investigation. He goes on to say, even if it is accepted that Ms. Puri Buch did not have an actual bias in the investigation, either in favor or against Adani, I feel that by applying the Pinochet principle, she was absolutely incompetent and disqualified to be part of the decision-making of SEBI, and in particular in conducting or supervising the investigation against Adani. I spoke to another eminent senior counsel who does not wish to be named, but he also concurs. He points out there are two issues with regard to Madhabi Puri Buch. The first is with respect to impropriety on her part, regardless of allegations in respect of Adani, which is the 99% holding in the consultancy firm. The standard has to do with transparency in public dealings, full and fair disclosure by top regulators of assets and financial interests, and also activities of a spouse who could, through his holdings, cast a shadow on the regulatory authority of the SEBI chief, is required. The second and separate issue, he says, is with regard to potential perception of bias in the Adani affair. There, and I quote, he says, "I think Buch has fallen short of norms. I haven't studied the issues, but I fully agree with the Pinochet principle that you cannot be associated with an investigation where there are financial or other perceptible connections with the Adani group, either directly or through a spouse or indirectly." In effect, it's not about financial misconduct. It's not about overt impropriety, which again is a matter of investigation, but about whether the actions of the SEBI chairperson meet with the ethical standards expected from a regulatory body. So just as Lord Hoffman's failure to recuse himself was considered an institutional embarrassment in the Pinochet case, this is certainly an embarrassment for the market regulator and has cast it into enormous turmoil. The fact that SEBI executives, past and present, are vague about the prescribed rules of conduct is another indicator of how opaquely the regulator has been functioning for 3 decades. A body that's putting out new rules for market intermediaries and infrastructure institutions almost on a daily basis doesn't seem to have looked inwards or framed a clear rule or code of conduct for its own officials. This is a serious failure, not just on the part of SEBI, but the Finance Ministry, the Appointments Committee, as well as the Central Vigilance Committee. It needs to be addressed immediately, not only addressed by the Finance Ministry, but also questioned by Parliament. Will it happen? It is in all our interests that this should happen because we need our regulator to be impartial and seen to be impartial, like Caesar's wife. If you agree, subscribe and spread the message. Thank you.